Well, it's a great privilege, and I hope I can interest you, and I really would like you to have the opportunity to say something. So at any time, just speak, and I will stop and take your question. I think the most important thing, from my point of view, is to try and convey to you my experience over the past 27 years as quickly and clearly as I can. I've used this slide to give you a guide as to where I'm going to take you, hopefully. And that is that I thought I discovered sexual abuse. And then I went through an experience of discreditation. And I'm not complaining about many of the criticisms that were made of me. But it's interesting that the word discovery in the dictionary is followed by the word discredit. Then I was disciplined. Then there was a long period of about 20 years where there was a discussion, largely around whether or not a restriction on my clinical practice should be lifted. And this delay went on until I forced my employer's hand to either lift it or make it permanent. And they made it permanent. And I suffered a bit as a result of that. And then I decided to challenge them. And then they dismissed me. So that's the story that I'm going to describe to you. There's another underlying subtext, and that is how politicians control the extent that doctors have been able to help a generation of children who may have been sexually abused between 1987 and now. I think that since Cleveland, children have largely been left with the responsibility of disclosing sexual abuse themselves. And I think that that's pretty disgraceful. And that brings me on to something that we might discuss at the end, and that is whether sexual abuse and other forms of child abuse are so difficult in terms of dealing with that doctors need to be told, you have the protection of law to report your concerns, regardless of the outcome. Because I'm concerned about children who can't speak themselves, because I haven't been able to speak myself for the last 17 years. And I think that traumatic experience is something that we need to know a lot more about and appreciate. So the story begins, and these, when I put a slide up, and I'm sorry that some of these slides are a bit busy, but I'm keen not to deceive you. So I have put in italics quotes from the Cleveland report. And what this slide describes is that my first encounter with sexual abuse was something that I didn't recognize. I saw a baby with a vulval tear, and I thought that it was non-accidental injury of the genitalia. Now, at that time, I was 33. I had been in paediatrics for 8 years, and I didn't know anything about sexual abuse. Didn't know it occurred, and made the assumption that this was a child who'd been injured in the genitalia. And when the police told me that the father had admitted to a sudden sexual urge and had sexually abused the child, that meant very little to me. I then met Dr. Higgs. She was appointed at the beginning of 1987, And she had an interest in social paediatrics. And she showed me what anal dilatation looked like. And I found it quite a striking physical sign. And in terms of thinking about its significance, then, that was the position, that it was associated with sexual abuse, provided there wasn't a stool in the anal canal, or that when you saw into the rectum, it was empty. And that the main message of this physical sign was that it was a sign of sexual abuse. Now, it's very difficult to reposition yourself without sort of predating yourself as a doctor before the Cleveland crisis. There's a chap called Carr who talks about history and the influence of the present on how you view the past. So, looking at these early slides, it's impossible for me to not see or think about the Cleveland crisis. But at the time, all this seemed to be very much a matter of fact. Dr. Higgs and I were talking, we were trying to work out what to do, and we didn't know for one moment that there was going to be the most enormous uproar as a result of what we were doing. And the most important thing was that this physical sign raised the question of my obligation to the children as their doctor. And the question arose in my mind as to how many patients I had missed or let down because I didn't know about this physical sign and I didn't think about the possibility of sexual abuse when I was seeing them. And so I decided it was important to address this deficit and do something about it. And it was in April of 1987 that I saw a little girl, and as a result of my concern about bruises on her body, including a bruise on the mons pubis, I asked to see other children in the family. I examined one of the siblings, did the test for anal dilatation, and saw for the first time in one of my patients the signs of anal dilatation. And I concluded that the child had been sexually abused and informed the social services. Now, that was still related to non-accidental injury. And what this slide describes is how Dr. Higgs was seeing a few patients that I had been involved with in May of 1987, and she thought that they had been sexually abused. And the diagnosis of sexual abuse in one family was a significant milestone in my growing perception of the problem. There was no association with non-accidental injury. That was a big point in my thinking. I had known the children for 2 or 3 years and had tried to deal with their problems. They were seen by Dr. Higgs, who made a diagnosis of sexual abuse and sent them to Dr. Wynne at Leeds for another opinion. Both these paediatricians observed anal dilatation and other signs considered to be consistent with anal penetration. So I then, when I gave evidence, I said that the diagnosis in respect, and that was in December 1987, that in respect of this family, The diagnosis in respect of this family caused me great concern because I realized I'd been looking after the children for some time and had missed the true diagnosis. I told the inquiry that it was part of the continuous process of self-questioning I was going through. At the beginning of May, there were 2 further cases. The health visitor referred to me a family that I'd been looking after for some time because of failure to thrive. And on this occasion, on examining the 2 children, I diagnosed sexual abuse, and my diagnosis was confirmed by Dr. Higgs. The children were subsequently placed with foster parents, where Dr. Wyatt told us they subsequently thrived. On the same day, I saw a child in the outpatients for review, examined the child, found signs consistent with sexual abuse which were confirmed by Dr. Higgs. And I told the inquiry, I realized I'd been trying to help this child and her family for 2 or 3 years without discovering the problem. These children were all diagnosed during the first wave of admissions in the first week of May. So, I think that's probably the end of busy slides. So, what I would like to convey to you is that one of the main problems with a doctor detecting possible child sexual abuse, where there was no previous concern about child sexual abuse, is that it throws up 2 issues which were central in the Cleveland crisis in 1987. The first one is the scale. There are more patients or more children where a doctor is going to raise concerns than the numbers of children who can raise concerns themselves. That's a very important factor. The second is that the doctor is putting himself or herself in basically the same position as the child and disclosing the possibility of sexual abuse in a consulting room. Now, that situation is full of difficulty, and it was that which started the Cleveland crisis in one sense. It was also central in the considerations of the judicial inquiry, and it was at the heart of the criticisms that the judicial inquiry made of me making a medical diagnosis. And what the inquiry report said was, it seems clear from the evidence that his diagnosis, based on the clinical signs, was given to the parents as soon as he had completed the examination of the child in clear and unequivocal terms, and before any discussion with social workers or further investigations were carried out. In the context of child sexual abuse, this practice was unwise. So the inquiry was unambiguous in criticizing the making of a medical diagnosis in a consulting room. Now, one issue was the accuracy of the medical diagnosis. And that is addressed in the Cleveland report, because the independent second opinion panel was set up in June in response to a request from Mr. Bishop, who was the Director of Social Services in Middlesborough, to the health authorities to make arrangements for the clinical assessment of children diagnosed by Dr. Higgs and Dr. Wyatt as having been sexually abused. The intention was for an independent panel of consultants to provide second opinions in a number of cases where the diagnosis was in dispute. So this was going on in June. And I had known nothing about sexual abuse in the January, and I had made my first diagnosis in April, and I was having patients that were being seen by the independent panel in June, along with Dr. Higgs. And the independent panel was made up of an eminent paediatrician and an eminent child psychiatrist, not necessarily from the same region. The panel saw a total of 29 children from 12 families, of which, in the case of 12 children who had been diagnosed as having been sexually abused, the diagnosis of sexual abuse was confirmed by the panel. In 4 cases, the initial diagnosis was sexual abuse and the panel did not confirm it. In the cases of 6 children who had been diagnosed as being sexually abused, the panel considered the medical signs sufficient to have merited further investigation. And in 7 siblings who were examined, and the original diagnosis by the paediatricians that no sexual abuse had occurred was supported by the panel. So if you tot those figures up, they come to 25. So the independent panel looked at 29 children. They agreed with either the diagnosis or the grounds for further investigation in 25, which is 86%. Now, at the same time, the parents were becoming increasingly concerned, and there was growing distress, anger, and frustration of the parents, and that found expression in the weekend of the 18th of June. That's a very important date, the 18th of June. The parents of 3 children diagnosed early in 1987 as having been sexually abused described trying unsuccessfully for 2 or 3 months to obtain information about any national support group for parents. So the parents, quite understandably, were as described. And they found support from the Reverend Michael Wright, who gave evidence at a later meeting on the 20th. He gave evidence to the inquiry. Again, what's written down is in italics. On the 22nd of June, he attended a meeting with Mr. Bishop, at which he outlined to Mr. Bishop the main concern of the parents. He said that at this meeting, Mr. Bishop suggested he was treating all the parents as being innocent, but he explained that this was not the case, and he could identify, that's the Reverend Michael Wright, at least 3 categories of parents. There was a small group who accepted that their children had been abused and were grateful for the diagnosis. There was another small group who did not believe the diagnosis and could not work out where, when, or by whom the abuse had taken place, but nevertheless accepted that the doctors must be correct in their diagnosis. These parents became suspicious of their family, friends, and neighbors. The largest group were those who believed there had been a misdiagnosis, there being nothing to substantiate the medical diagnosis. The demands and announcement of the statutory inquiry. When you think how long it's taking the present inquiry to get off the ground, you can see here in 1987, it's taking only a matter of weeks. Mr. Bell, the Member of Parliament for Middlesborough, compiled a case file, and the inquiry was provided with information sent to the Minister on the 6th of July. So that's 3 weeks after the parents saw the Reverend Michael Wright on the 18th of June. Mr. Bell provided case notes to the Minister in respect of a total of 19 children from 11 families. In addition, other children were referred to during the inquiry in whom Mr. Bell had taken a particular interest, another 3 or 4 families which were considered the families concerned fell into three groups. So, Mr. Bell delivered the file containing his observations and the results of his inquiries to the minister, and on the 9th of July, Mr. Newton announced in a statement to the House of Commons the setting up of a statutory inquiry. Now, this is the first statement in the Cleveland report, and the reason for putting it up is because it confirms that Lord Justice Butler Schloss was not looking into the accuracy of the diagnosis. She was looking into the arrangements for dealing with child abuse in Cleveland since the 1st of January, including particular cases of child sexual abuse. She submitted a report along with her recommendations a year later, in July 1988. The Cleveland inquiry did not look into the accuracy of the doctor's diagnosis. The terms of reference of the Cleveland inquiry presumably came with or after the announcement of the statutory inquiry on the 9th of July. The independent panel had been set up in June 1987. The intention was for an independent panel of consultants to provide second opinions in a number of cases where the diagnosis was in dispute. And again, I've repeated the figure 86%. I gave evidence in December. The inquiry started on the 4th of August, and it went on for 74 days. My position when giving evidence to the Cleveland inquiry in early December 1990, that should be 87, is described in the report. The report was published on the 6th of July 1988. In it, it says, "the future." It then refers to what I said in December 1987. At the time that he gave evidence, that's me, to the inquiry, he, Dr. Wyatt, was both convinced and committed to his approach to the problem and felt he could not ignore his responsibility to the children. Now, when I had given evidence, my employers were obviously concerned about what to do. And they had provided me with minutes of meetings that they held in December 1987. And what those minutes say is that it was, this is from the point of view of my employer, it was imperative that interim measures were taken to maintain public confidence in the services provided in Cleveland and yet not deter other clinicians from diagnosing child abuse. And the minutes continue. Clearly, there were considerable difficulties in marrying together these various objectives, but a number of options had been discussed, and avenues for redeploying the consultants were being explored. The member group had been unanimous in agreeing that it would not be possible to do nothing and allow the two consultants to return to their previous duties. And this was over 6 months before the publication of the Cleveland report. Following an extensive discussion, it was agreed to support the action proposed by the member group that neither consultant should in the immediate future have anything to do with the management of child sexual abuse cases, with Dr. Wyatt returning to South Tees. So, December 1987 was when my restriction began. My employer put it in place after I had said at the inquiry I was both convinced and committed to my approach to the problem and felt he could not ignore his responsibility to the children. So I was called up to see various individuals in those 2 or 3 months prior to my returning to work on the March the 1st or thereabouts in 1988. And the point of this slide is to raise with you the idea that the restriction on my clinical practice began when my employer was considering when and how to let me go back to work after the Cleveland crisis. And my legal advisor wrote to one of the members of my employer and said that because the issue of child sexual abuse has generated so much heat, and this is after a telephone call between my legal advisor and my employer. So if I could just repeat that, because the issue of child sexual abuse has generated so much heat and public concern in Cleveland over the last 9 months, the region considers it wise that all 4 professionals primarily involved over this period should voluntarily withdraw from child sexual abuse until such time as matters have resumed a more even keel. It is for this reason that it is suggested that Dr. Wyatt should withdraw from child sexual abuse, and not because of any criticism of his past conduct. So, my voluntary withdrawal from child sexual abuse was to form the basis of disciplinary action taken later in the year, when it would be described as a loss in clinical freedom. And yet I still had to recognize possible child abuse in patients under my care without access to multi-agency working, a key recommendation of the Cleveland report. And this restriction required me to pass my patients, or those patients where I had concerns, on to colleagues. Now, I didn't really see much of a problem at the time. But in retrospect, I'm going to put this hat on because it was the beginning of the next 20 years, but I didn't spot it.
Can I just ask that the slide before last where you said voluntarily?
Yes.
Who wrote that?
My solicitor.
So that wasn't a statement from your employer?
No, but my employer had suggested it. And subsequent slides will show that that is the position.
They accepted that?
Oh, yeah, I was asked, in keeping with the minute that I was not privy to, obviously my employer was discussing things at that time, in December, they treated Dr. Higgs and I differently. And after we had given evidence, one of the members of my employers contacted my legal advisor, a solicitor, and the letter from which that comment is taken is a letter confirming my solicitor's understanding of a telephone conversation, which I can show you if you want.
Jeff, could I ask you as well, please? When you say you're an employer,
Yes.
were you at any time given any knowledge about who exactly had advised your employer? In particular, what was the medical input into the advice that your employer?
Yeah, the regional medical officer at the time became the chief medical officer, Sir Liam Donaldson.
But did they take advice from colleagues within their own employ, or did they take advice from specialist paediatricians elsewhere? Or don't you know? Weren't you done?
I have been trying to avoid naming anyone because I am frightened of them.
Well, you don't have to name, but just whether they were medically
I am aware that I am aware, as as will be evident in the next few months, that my employer took soundings from doctors, and I would regard my advice to you in the course of this presentation is to see this as a process, not an event. And so I think that they thought that they were going through the same process that I claimed to have been going through in 1980, a year earlier, in conversation with Dr. Higgs. So I don't know, but I know that they were talking. And there was a lot of input over the course of the year. I also said in January 1988 that I am anxious that the proposal, i.e. the restriction, should not be interpreted, in my view, quite wrongly, as an admission by me that my management of child sexual abuse in the past has been at fault, and that he is in any way being punished for this, not least because this might deter other professionals from tackling a very serious and difficult problem. So I was keen to assist my colleagues. I didn't know what the report would find, but I felt confident in January 1988 that, having given evidence and thinking that the diagnostic accuracy was as it had been described by the independent panel, that I couldn't see much of a problem, and that I would assist my employer by going back to work with a restriction, given all the trouble that had occurred in the previous year. Politically, I then went for another meeting with my employer, and this was the letter they wrote, part of the letter they wrote to me after I had agreed to take the restriction, which is why I am wearing this hat. Finally, I did remind you of the fact that we would be reviewing your personal position after the inquiry report is published. This review would have two purposes: to allow the Regional Health Authority chairman to decide whether there is any aspect of the inquiry report's findings which alters the Regional Health Authority's previously held view that serious disciplinary action against you is not warranted. So there we have it in writing, that my relative confidence that things would be okay was not an isolated view. It was the view of my employers at the time. That was February 88, which was 4 months before the publication of the Cleveland report. And the letter continued, the other reason was to establish whether there is critical mention in the inquiry report about other aspects of your conduct or practice which, though falling short of the need for serious disciplinary action on the Regional Health Authority's part, nevertheless will need to be taken up with you by us. I still didn't think there was going to be a lot of trouble. And then the report was published, and I have taken these headings. I had a leading role. There were patients that I had made a diagnosis. Dr. Higgs had been doing the same. There were large numbers. There were people saying to me, don't you think you better stop? Or do you think can you just slow down? Or this or that? And I had a real problem with that because of what I had said earlier, that I thought I had a duty of care to the patients. And just as I couldn't not make a diagnosis of bronchiolitis or any other pediatric condition, I continued to make a medical diagnosis of child sexual abuse. I was criticised for, these were all criticisms, they were all in the Cleveland inquiry, and I don't mind going through them, but I'm hesitant without actually reading them to you. But I was criticised for my response to requests for second opinions. There was no doubt that going through this experience was emotionally very challenging for me, and when they brought the regional reference team in at the end of June 1987, some doctors were saying one thing and I was disagreeing with them. The other major criticism of the Cleveland report was this idea that if a doctor made a diagnosis of child sexual abuse, because of the existence of place of safety orders, which went for 28 days, there was a situation where the child would then be removed from the parent, either into hospital or into a foster home, and disclosure work, in inverted commas, would be carried out. That was a major concern on the part of the Cleveland Inquiry report. They were critical of my lack of reading. I hadn't read some articles. I hadn't attended case conferences. My medical notes were insufficient. And the other thing that the Cleveland report were very concerned with was the fact that I told parents what my opinion was. In child protection work, it is customary to see the siblings of children where there is a concern, but that puts the numbers up. And that was another concern. Where were they going to go? So, when you look at the conclusions in the Cleveland report, it's worth going through this because it's quite important. Dr. Higgs and Dr. Wyatt, so these were the central conclusions of the Cleveland report. Dr. Higgs and Dr. Wyatt became the center point of recognition of the problem. Between them, in the 5 months, mainly in May and June, they diagnosed sexual abuse in 121 children from 57 families. Children were referred to them in various ways. Some were brought by social workers because of a suspicion of sexual abuse or allegations or complaints. Others were referred by family practitioners, health visitors, or community medical officers because of a suspicion of sexual abuse. A few from within the hospital were referred by junior medical staff or by nurses. In some, the diagnosis arose on children attending outpatient clinics with medical conditions in which the possibility of sexual abuse had not been previously raised. That they are a very important group. Many were siblings of or connected with these children. By reaching a firm conclusion on the basis of physical signs and acting as they would for non-accidental injury or physical abuse, by separating children from their parents, and by admitting most of the children to hospital, they compromised the work of the social workers and the police. The medical diagnosis assumed a central and determining role in the management of the child and the family. It was entirely proper for the two paediatricians to play their part in the identification of sexual abuse in children referred to them. They were responsible for the care of their patients. Nonetheless, they had a responsibility to examine their own actions, to consider whether their practice was always correct, and whether it was in the best interests of the children and their patients. They are to be criticized for not doing so, and for the certainty and overconfidence with which they pursued the detection of sexual abuse of children referred to them. They were not solely, nor indeed principally, responsible for the subsequent management of the children concerned. However, the certainty of their findings in relation to children diagnosed by them without prior complaint posed particular problems for the police and social services. So, I was quite surprised by the report, basically because I didn't appreciate what the object of the exercise was. And I think it's probably worth reading to you extracts from a report that was of the Cleveland Inquiry at the Medico-Legal Society in London, at the Royal Society of Medicine. And that was on the 9th of March, 1989. And the reason for reading it to you is that it addresses one of the central misunderstandings around the Cleveland Inquiry and why I was surprised. So there's a solicitor asking Lord Justice Butler Schloss questions after her presentation. And what this solicitor was asking was informed because he knew about the Cleveland cases. He wasn't my solicitor, but he worked in the same company. And what this solicitor asked is as follows. Do you think it might in fact have been better if the government had asked you to decide whether these children had been assaulted individually, and whether in fact it was really fair to the courts that had to try the wardship when there was such a wealth of sophisticated evidence being placed before you, and if it would not in fact have been better if they had asked you to deal with the whole thing? And Lord Justice Butler Schloss replied, 121 children, 165 children, of which 121 were said to have been sexually abused. We spent 7 months looking at the arrangements. We had 30 doctors who gave evidence, probably more than 30 doctors, looking at what was the way forward. If we had tried each individual case, I could not have sat with assessors trying each individual case as chairman of the inquiry. I do not see how I could have done that. The parents and the children were entitled to privacy and the care that we would give each case. One of the important elements about the wardship cases was that they were very largely compromised, for perfectly good reasons, I have no doubt. I do not know why they were compromised. It meant that the welfare of the children which is the first and paramount consideration, was first looked at by every judge in the 67 cases. And then the solicitor came back to her and said, is not the answer to that, with all of it practically compelling as it may be, that one question was being posed which had been answered, and that it was being answered in the wardship proceedings on the basis of evidence which was incomplete and on expertise which was incomplete by comparison with that which was placed before you. Lord Justice Butler Schloss said, I think that the duty that I had from the Secretary of State was to try and see what recommendations the assessors and I could give in order to prevent just that which was going on in Cleveland at the time. And it was more important for me, it seemed, to get on and say, This must not be allowed to happen anywhere in the country. We must look to see how to prevent it in the future rather than to have dealt with the individual children. So, what that says, as far as I'm concerned, is it offers me an understanding as to why I was surprised when the report came out, because I had been expecting it to focus on the question of the accuracy of the diagnosis, and it wasn't concerning itself with that. And then the politicians became involved. On the same day that Lord Justice Butler Schloss presented her report in Middlesbrough Town Hall, there was a debate in the Houses of Parliament, and the Minister of Health said, and these were extracts, the report contains substantial criticism, both of individuals, including the consultant paediatricians, Dr. Higgs and Dr. Wyatt. It is for the authorities involved in the first instance to address those criticisms and take the necessary action. The government expect that action to be thorough, speedy, and effective. But the plain fact is that what happened in Cleveland should not have happened and must not be allowed to happen again. The measures announced today are designed to see that it does not. The Cleveland report had a short version and a long version, and the short version was available to everyone. The longer version did have an important paragraph in it, but it didn't appear in the short version. And what Lord Justice Butler Schloss said was, many of the comments made about Dr. Higgs at pages 143 to 145 apply equally to him, that's me. He too shares a responsibility for the crisis. But as with Dr. Higgs, it would be an unjust oversimplification to place the whole burden of the crisis upon the shoulders of Dr. Higgs and him. There were many other contributing factors to the crisis. And interestingly, there was no recommendation of a restriction in clinical practice in the Cleveland report. The medical profession was not very sympathetic. The kindest description of Dr. Higgs and Dr. Wyatt would be to say that they were naive. But naivety should not number among a consultant paediatrician's characteristics. The situation changed. From then on, it was downhill. This is an extract from the letter describing the disciplinary action my employer was taking against me. We think that the issue of professional competence in this case turns less on the question of accuracy of the initial diagnosis than on the influence that the diagnosis, the way in which it was conveyed, and the initial medical management had on the overall management of the children and families. We consider that you shared a major part of the responsibility for the way the children were managed. There was a further aspect of your conduct for which you were criticized in the inquiry report and which troubled us greatly and was repeatedly criticized by others within the profession from whom we took soundings. That was the extent to which you continued to diagnose more and more cases when there was no supporting infrastructure to deal with them. This placed intolerable pressure on hospital accommodation, on nursing staff, and on the capacity of the Social Services Department to undertake the necessary follow-up work and further investigation. We think you should have been willing to look at alternative ways of handling the situation. We consider that your clinical judgment and professional conduct fall just short of compelling us to embark on disciplinary action which might result in your dismissal. In other words, initiating a 61112 inquiry. From what I have said to you in our meeting and from the contents of this letter, I think you will appreciate that we are in no doubt that very serious action must be taken. When we met, I said that you should regard this statement I have made to you as being a severe reprimand. This letter is written confirmation of my decision and also is a warning that any future allegations which were substantiated about your competence and conduct would be dealt with quickly and severely. Because of the high degree of public concern about this matter, we intend to make the fact of this reprimand public through a press conference. So, from then onwards, I looked and felt like this. I shan't put the trousers on. As for your future working arrangements are concerned, we are prepared to let you return to Cleveland, but only if you are prepared to work under your present arrangements, not dealing with child abuse cases personally, but handing them over to a colleague. This arrangement will persist for the foreseeable future. In other words, it will be a long-term arrangement, reviewed from time to time. There was one mitigating factor to many of the criticisms, though not all of them, particularly in relation to the poor note-keeping. And that was that Lord Justice Butler-Schloss did recognise and say there can be no doubt that during May and June and the early part of July, both doctors were grossly overworked. And there was a confidential document sent by my employer to the government. It was entitled Action Taken Following the Report of the Judicial Inquiry into Child Abuse in Cleveland. It was almost a response to what was written in Hansard. We expect speedy action. So this was a reply to that request. And in that document, which ran to about 28 pages, there was a page entitled, Was the level of diagnostic accuracy too low? Assessment of this point was particularly difficult without first being able to establish what proportion of the diagnoses were valid. I've put the bold in. The true figure will never be known, and the Butler-Schloss report makes no attempt to estimate it. It is clear that there was no wholesale error of diagnosis. Many of the cases diagnosed by Doctors Wyatt and Higgs were later found to be genuine and serious cases of abuse. As to the actual proportion, some light is thrown on this by the investigations of the independent panel and regional reference group set up by the regional medical officer. The independent panel, comprising eminent paediatricians and child psychiatrists from outside and within the region, and working in pairs, undertook extremely thorough and in-depth assessment of the children and families. The inquiry report concludes that in 25 out of 29 children examined, the panel either agreed with the original diagnosis of the Cleveland paediatricians or felt that the children had medical signs sufficient to have merited further investigation. Amongst the reference group cases where the second opinion was given by another consultant paediatrician from within the region, in 14 out of 22 cases, the second opinion paediatrician agreed with the original diagnosis or considered that there was cause for concern and further investigation. It should be remembered that this was a selected group of the Cleveland children, so the extent of abuse could have been higher or lower in the larger population. The figure for correct diagnosis or of cases justifying further investigation, most often cited by the professionals who were closely involved with the Cleveland cases, put it at around 70 to 75%. If the figure of 70 to 75% of correct diagnosis was true, it could clearly be contrary to general public understanding of the accuracy of the diagnosis. In professional terms, it would still be necessary to raise the question that if 25 to 30% of the consultant's diagnoses were false positives, does this constitute professional incompetence? This raises fundamental questions about the accuracy of diagnoses in other fields of medicine where the proportion might be considerably lower for an initial or working diagnosis. I've always thought this paragraph was the most troubling of any paragraph I have read. And that is, there is no doubt that these measures involving a public reprimand and restriction of clinical freedom and unprecedented for an employing authority against members of its consultant staff will be seen within the profession as severe disciplinary action. I don't know about you, but I find that paragraph very concerning. The public announcement went out 2 months later. On his professional competence and professional conduct, I concluded that Dr. Wyatt's actions fell short of compelling the authority to dismiss him. The authority, in confirming my conclusion, also supported my decision to take serious disciplinary action against him, comprising a severe reprimand, a warning as to further conduct, a restriction of clinical freedom so that he will not have involvement in child abuse work. In taking this serious disciplinary action in the light of decisions taken elsewhere, we are conscious that some will say that we have made Dr. Wyatt a scapegoat. How other bodies deal with their employees is a matter for them, and the authority had to do what it thought was right in the circumstances. I was not reported to the General Medical Council at any time. If I had, then any conditions applied to my practice would have been reviewed every 3 to 6 months. And in the absence of a health problem, it would be very unusual for any conditions to remain for longer than 5 years. The first review that occurred when, in my case, was 8 years later. In 1996, there was a review hearing into the restrictions imposed upon Dr. Geoffrey Wyatt by the then Northern Regional Health Authority. Findings of the hearing, which was held from the 3rd to the 5th of July 1996, included the following. The panel formed the view that Dr. Wyatt was a very capable and competent paediatrician. The panel take the view that the existing restrictions do place a small number of children at some extra risk. This extra risk is minor, but a risk nonetheless. The uniqueness of the restriction and the extra minor risk to children attributable to the restriction and the child protection systems now in place nationally and locally have been the central features of our deliberations and have shaped our decision and recommendations. The maintenance of public confidence in the child protection service is a responsibility of all those individuals and agencies involved, and they recommended lifting the restriction. But the difficulty was they had to find a consultant from outside the hospital to be my supervisor or my mentor, and that was never possible. When I pushed it further, some years later, these comments appeared in various correspondence. That in 2006, in correspondence with the National Clinical Assessment Service, the statement was written, "Nor was your eventual return to child protection work within the same community something that the Trust could sustain." That would have been the case at the very outset. The major issue here are of patient care and reputational risk to an organisation which cannot afford to be in the same place twice. Only last week, Dr. Higgs stated to a BBC News reporter that she felt that all her diagnoses were correct. We cannot run the risk of you being exposed to the same situation and offering the same response as Dr. Higgs. My employer said in 2006, "I believe this trust has treated you fairly since 1987 and could have taken a much more antagonistic view of your behaviours at the time." My employer stated in 2007, "However, I should emphasise that despite this issue, the lifting of the restriction, you are a highly regarded senior clinician, both by colleagues and senior management in this organisation, and there are certainly no issues with regard to how you are seen or viewed as a clinician or the degree to which you are trusted as a colleague." If I had been reported to the General Medical Council in 1988, any imposed conditions would have been subject to review every 3 to 6 months. 20 years on, the continued restrictions placed on me by the Trust are highly disproportionate and over-punitive. Maximum period from the GMC to apply, for the GMC to apply any conditions to my registration is 5 years. Has my restriction for 20 years violated my human rights, I thought. As a consequence of your stated intention to continue to challenge your restriction in relation to child protection work, I am now informing you that you have been immediately excluded. 30th of April 2010. 5th of July, it is with regret, therefore, that I am notifying you of the termination of your contract of employment with the Trust with the effect from the 2nd of July 2010. I have undergone training and gained qualifications in forensic medicine. I am now working as a locum consultant paediatrician in an NHS hospital doing child protection work, writing reports and giving evidence. The end. Thank you.